Um, let's record this and we are on the record. We're on the record. So you can go ahead and take over, Jazz.
Okay, where's our PowerPoint?
Oh,
Are
you
we-
want to start? Okay. Okay.
Absolutely. Let's jump right in.
You want to go just jump right in? Okay, hold on. Let
Yes,
me
sir.
let
Yes,
me
sir.
share. Let me share. Hold on one
The
second.
first slide is the introduction slide. So,
I saw that. All right, give me a second.
I saw it up there when we first logged in. So,
No, I got it. I just gotta when you start recording something, the buttons and stuff change around, so I can't find where that's at. So
no problem.
there you go. Right there. There you are.
All right. Thank you.
Hold up.
All right. I was going to say, yeah, I definitely need that a little bigger. I'm going to have to
Hold
put
up.
on glasses. Mhm.
Hold up. That's not still not big enough.
That's good. I just got to put my glasses on.
I see
This,
what happened. There we go. That shit is that good?
yeah.
All right, there we go.
Okay. Well, good evening, everyone, and thank you all for joining. And thank you for having me. Um, of course, we have a PowerPoint, so we're just going to kind of jump right in here, ladies and gentlemen. Um, I am Jazmine Greer. I don't know if Han didn't introduce me, but again, I'm Jazmine Greer. I'm an attorney. I'm also a licensed title agent, although I don't really do any title work. It's something I decided to do just to have it under my belt. I'm also a real estate investor, so that means I invest my own money in real estate. And having done so, I've been able to run into situations that as an attorney I would not have experienced. And so through my own investing, I've learned a lot as well. Again, I'm also a speaker, so I spoke at a lot of events, and I'm a teacher. Not only do I teach for hand, but I also teach CLEs, which is continued legal education for other lawyers. I started my own law practice at the age of 27. And when I started my practice, it was in 2008. So at that time, as it relates to real estate, I primarily focused in foreclosure because, again, in 2008, at that time, we had a housing crisis, foreclosure crisis. So I was able to jump right in and do foreclosure defense and assist some homeowners that were impacted by that crisis. Now in my real estate practice, as I indicated earlier, I teach and I invest. I also do anything, as I tell people, from acquisition to disposition. So anything in between development and what I don't know, I try to learn because I really like practicing law and I really love real estate. Um, as I indicated before, I've taught legal education to other attorneys through the National Business Institute. And I'm thankful to be here with you all today for the agency success training. And this is my third year. So again, I'll be talking about contracts. So we can go to the next slide, please.
Can you see it?
I know I cannot.
Hmm. That should be
Okay.
much better.
All right, here we go.
All right.
So, although throughout my career, and I've been practicing, now is 16 years. So I will say throughout my career, I've heard people define the elements of a valid contract as being a lot of different things. But I think the core and what you guys will probably see on your test are these five elements: offer, acceptance, consideration, legal purpose, and competent parties. And with that, we can go to the next slide.
Let me add something in here. Remember when I said on in the class real quick, Jazz, in the book, they can they combine offer and acceptance. So in some instances it would be for. That's the whole process. And some people like Jazz, she separated them. Those are two different things, offer and acceptance. But in some books they put them together. All right, and they
Mm.
call it, So I just wanted to make that differentiation because there is five, and in our book it says four.
Okay, and as he indicated, again, we do combine the offer and acceptance because they kind of go hand in hand. So throughout my PowerPoint and my outline, I have talked about them as one subject. So here again, we're starting off talking about offer and acceptance. I think it's important to understand and define these roles. When I taught the class the first year, Andrea had gave me a comment that maybe we should have defined the words offer and offeree. And I guess as from a broker's perspective, that is an important thing. Maybe on the test, it's an important thing. So I think again that this is something important to define. So offer or whenever you hear or, it's like the person with power, right? So employer. So again, the offeror is the party that makes the offer. Typically in Ohio real estate transactions, the offeror is the buyer. And I know it may seem a little out of order, but because you have the seller listing their property. But again, don't get confused. The listing is not an offer, it's a solicitation for offers. So again, the offer is usually the buyer, and they'll send a purchase agreement with their offer to purchase the property that the seller has listed. Then there's the offeree. And again, at the beginning of the transaction, usually the offeree, and again, the defined offeree, that's the person that receives the offer. So the offeree at the beginning of the transaction is usually the seller. However, as the transaction plays out with counter offers, contingencies, and the like, when those things come into play, the offeror and the offeree position changes between the buyer and seller, depending on who is making the offer. The offeree must unequivocally assent to the exact terms of the offer without altering or changing the offer. If the offeree does unequivocally accept the offer, then there is no mutual assent or meeting of the minds. So again, as Han indicated, the reason that we look at these things together is because together they make up what we call mutual assent, or as a lot of people have heard, meeting of the minds. I don't like the idea of meeting other minds. When I was in law school, my law school professor said minds don't meet. But people say it all the time, so run with it. But again, when you have an offer and acceptance, you typically have mutual assent of the parties. So we can go to the next slide.
And let me add something in here, and it is nothing about what you said. I just want to let them know what to focus on. Know what an offerer is, offer or, right? Know what an offer e. One of the ways that I typically try to remember this is when I see this REE, I think of receiving. I'm receiving something, right? And this OR is I'm a giver. I'm giving something. So specifically in this relationship, the offeror is the one that's giving something. The offeree, REE, receiving, is the person that's receiving something. For the test, know what the offeror and the offeree is, and also know that that can change if the person who is the offeree doesn't unequivocally accept that offer without any changes to it. So that role can change. And what I mean by that is if I send Jazz a contract and she says, okay, I like everything, but as soon as she says, but that's a change. If she changes anything in that contract without completely agreeing to it, then she becomes, it switches. Now she becomes the offerer. She puts her change in there, and then I become the offeree. That's going to be on the test. You need to understand that the offerer and offeree can change, to put it as simple as I can. All right, go ahead.
All right. So again, still on the subject of offer and acceptance. So as we already stated, acceptance is where the offeree unequivocally assents to the exact terms of the offer without altering or changing the offer. If the offeree does not unequivocally accept the offer, then there is no mutual assent or meeting of the minds. Um, a test note, this was a question that Ham had provided. So this states mutual assent in a real estate contract is best demonstrated by and in this example, it states a signed written offer and acceptance with specific terms that shows an intent to enter into an agreement. A written agreement should reduce the potential for disputes and will meet all legal requirements of an enforceable contract. So we're going to delve a lot more into writings and the specificity of the purchase agreements. But again, just to make sure we're understanding, there needs to be a specific offer. That specific offer needs to be accepted in its specific format without any alteration. And then we'll have, again, offer and acceptance, mutual assent. Um, just a little side note, since the practice of law is considered to be the creation of documents that affect the legal rights of parties, then preparing a purchase agreement could be considered the practice of law. Therefore, most realtors will use a standard purchase agreement that they just have to fill in the blank. So just keep that in mind when you're sending your purchase agreements as an agent, or whatever you're doing as an agent. Try to yield on the side of using forms when you're sending these offers, because if you try to create something from scratch, you could run into practicing law. So I don't know if you want any to add anything here, but if not, we
I,
can go to
I
the next.
wasn't, if you wouldn't have added that comment right there, I wasn't going to say anything.
Okay.
Really, where you get into trouble with what she just said is when you're preparing an addendum, right? And the language that you put in there, it sounds like an attorney wrote it and it got legal ramifications. You haven't run it by anybody at the brokerage. And because you're adding now it's what an addendum does is it's going to change the contract. So in essence, either the contract needed to be something needed to be added or taken away. And a lot of times when you're preparing an addendum, a lot of times you might want to run as a new agent, you might want to run past the language that you're putting in this stuff with an addendum. But pretty much what she's saying is don't go creating no purchase agreements on your own. Your company that you're going to work for is going to have the purchase agreements that they probably run through their legal. They're going to have all these forms that they probably run through their legal department, and you are simply filling in the blanks. When you find yourself writing and creating stuff, you may be bordering on practicing law, and obviously that's something that is a serious violation because you're not an attorney, and you may have a fiduciary relationship with someone and may put them in harm's way. And that's one of the things. The whole reason behind your taking the test is that this division of Ohio, the division of real estate in Ohio, wants to protect the public from incompetent people. That's the whole reason you got to learn about all of this stuff with contract law and agency. So with that said, that's all I got to say. But just be careful when if you're trying to create a document or something like that. My bad. I won't say nothing if you don't at the end if you just keep going. I won't say nothing. But go ahead.
Oh, the exchange is very well accepted. So again, more on offer and acceptance. I'm not sure how much they test on this, but I think it's important for us to understand when, again, I do a lot of investing and I deal with a lot of deals just as an attorney. And I think understanding when an offer is accepted is very important, or when it's not is important. One of the, again, rules, I don't know if you're going to be tested on, but that you, I think, should understand is the delivery or mailbox rule. This rule is kind of tricky because notice of acceptance, although it must be delivered to the offer or under the mailbox rule, an offer is considered accepted the moment the offeree mails the acceptance. So again, acceptance is about the unequivocal acceptance of the offeree. And when in which they're showing that they have unequivocally accepted the offer, they have to deliver that notice to the offeror. But the offer, the acceptance does not have to actually get to the offeror to be valid and to cause the offeree to be under contract. Now, of course, we're in a new day and age, right, where the idea of mail is sort of really antiquated, right? In this day and age, most things are sent via email. But with the federal and state laws that allow for emails to be considered valid signatures, you don't have to open the email or get the email for that offer to have been accepted. So, for instance, if a buyer sends a purchase agreement and the seller signs it, then it's accepted. I mean, it doesn't matter if you open your email or not, it's accepted. So say you have multiple offers, and I don't want to get too far into this, I'm going to talk about this in the next few slides, but if you have multiple offers and you didn't, open that one, I mean, that's the one that probably is accepted. You don't have to open the email and say, oh, I got it and I agree. No, because of the fact that, again, you sent it over, just signing it is enough. They don't actually have to receive it. There's some caveats to that rule, but again, the mailbox rule is about sending it and not necessarily having to receive it, making the offer accepted at that point. When I was in law school, it was really more intricate because it came up and we didn't, I graduated again like over 16 years ago. Emailing and all that was as new as some of the things that we're seeing new today. My point is that it was still fresh that mail was a thing. Now it's almost not a thing that we send mail. So they could accept the offer very quickly and you don't have to receive that email for it to be accepted. So we can go to the next slide
Let
on
me
the
give you
same
an
hashtag.
example of this. First off, y'all, remember this is on a test. Pretty much what she's saying is communication. Communication, like, is one thing to sign it. Okay, so I'm a role play. I send Jazmine an offer, right? Jazmine accepted it, but she didn't return it to me via mail or email yet. It's an accepted offer, but the acceptance hasn't been communicated to me. The minute she puts it in the mail or the minute she emails it, it's accepted then, right? Is that a good way to explain? Is that a good way to say it?
Yes.
Like the minute, like that's why diligence is part of your fiduciary duties, timely diligence. Because if you say, for instance, you got another job, and this has happened to me, admittedly, I got an offer sitting in my mailbox that I didn't see because I was working, right? And in the sense, I should have, I should have some type of alert. But I look at the offer and boom, I send it to my client. They say, yeah, let's accept this. They send it back to me. Boom. As soon as I send it back to that realtor, that offer is accepted. All right. And so this is on the test. So no, that it's not accepted until you communicate it, either through mail or to tell you the truth, you can't even call them and tell them that you accepted it. It has to be in transit.
Mm-hmm,
It has
mm-hmm.
to be in. You can't say, "Hey, we accepted that offer." No, it has to be in transit. Right
Yeah.
now, a solid agent, if you say something's been accepted, then it's accepted. But technically, it's not accepted until it's communicated through either a mail or email. That's the delivery mailbox rule. Acceptance is when you communicate it to the other party. All right.
Yeah. Just real quick while we on this slide, the mailbox rule does not apply in the context of option contracts. Um, and I know Hans going to probably get into this in another class, but you have like, option contracts typically are like your lease purchase or, option to purchase the real estate. That offer must be received by the offeror in order for it to be accepted because of the nature of an option contract. How do they know if you're exercising the option if you don't deliver it? And most every option contract that I've read does require delivery written. So again, just I don't want to get too far
Yeah,
into this.
they're not. It's
As
not.
purposes, again,
It's very
delivery and mailbox rule, but it does not apply in option contracts.
On
It has to
options,
be.
they won't get that technical with the options. It's pretty much what is an option and what is used for on the test. That's why I
Okay.
didn't even have them cover it because this is the meat and potatoes of what's going to be on the test. What you going over,
Okay.
right? I thought on it. Okay, there we go, right here.
Yeah. So, again, talking more about delivery, notice, and acceptance. So, in the context of real estate, you're almost always probably going to run into a situation where you have multiple offers, more than one offer, but theoretically, the seller can only sell their house to one buyer. Um, as such, the seller that entertains multiple offers is only under contract with the buyer that they deliver their acceptance to first. For instance, if the realtor sends their seller two agreements and the seller signs, hypothetically speaking, both at the same time, then the first agreement, the buyer, the first, I don't, this probably is a typo. The first agreement the seller signs is the one they accept. And the other agreement is void because it lacks acceptance. It doesn't have one of the elements of a valid contract. So it's void from the beginning. It's never signed by the seller in the certain time for them to have accepted the offer. So uh, again, weird scenario, like, but I think it's helpful to understand people always entertain multiple offers, and it's the first one you accept that you're under contract for. So if the next one came and it was 20,000 more, you're under contract for the one that was 20,000 less. You can't now, I mean, in certain instances, but theoretically, you're under contract and you can't get out. So understand that about multiple offers. Take your time to, usually people will set a deadline. That way they'll have all the multiple offers and then they can at one time decide which one they want. And you won't run into this for the most part. Counter offers and rejection. So again, we talked earlier about offeror and offeree and how who's ever making the offer is the offeror, who's ever receiving the offer is the offeree. That is a back and forth when we're doing real estate because it's all about negotiation. So again, if you don't unequivocally accept the exact terms and you alter even the smallest thing like the closing date, purchase price, anything, now that is a rejection of the offer and it is a counter offer. Therefore, it's a new offer that needs to now be accepted
Say that
by the
again.
offeree.
Say that this is really important. It's going to be on the test. Say what you just said again, if you don't mind.
Yes. So when a counter offer is made, any alteration of the terms, it's a rejection. Okay, flat out, like you're rejecting. I don't care if you change just the closing date, any small alteration to the terms of the agreement is a rejection. And if you then offer something again, changing the terms, that's a counter offer. Once you do those things, now whoever's making the counter offer is now the offeror and whoever has to accept the offer is the offeree. And again, they still have to accept the offer, deliver notice of their acceptance. Of course, again, the mailbox rule still applies. So in real estate, it goes back and forth until sometimes even the date of closing, you're still making changes that is a counter offer and an offer and a counter offer. And so until that deal closes, it's we'll get into this in a bit, but it's executory. It's still something somebody has to do. It's change in terms. So I don't want to get too far into that, but
Well, what I want to also have you talk about with this, because this is important, this is going to be on the test. So remember this. When you told me that it's considered a counteroffer when I change something,
mhm.
does that terminate that offer that I can't change it and then say, okay, well, you know what? I was just playing 5 minutes, 5 minutes later, say I was just playing. I accept that other contract or the contract as you sent over. When I change something and send it back to you, that terminated the last contract, right? It's gone.
Theoretically, theoretically. Now
Now
I don't
you
want
can
to get
submit
too
it again.
nuanced. I don't
You
want
can
to get too nuanced, but if I don't accept your counter offer, so once we have an agreement, right? We have a signed agreement and you send over an addendum with some amendments. I
no,
have
this isn't
to,
an addendum or an amendment.
okay, yeah,
This,
yeah. So I'm
this
saying
I'm
like
talking
it has
I'm
to
talking
actually.
I'm talking about if I send you a contract
Yes.
and you change the closing date.
Okay,
You said
before we signed it,
right, and
it
you
is not a binding contract. Therefore, we are going back and forth offering acceptance. But once we have a binding contract, but again, I think for the test purposes, whenever you see somebody changing terms or offering something different than what they were offered and they don't accept it as exactly it
mm,
was offered, then that is a rejection. Termination, I think, more so relates to a valid contract that is somehow terminated later,
well, no,
which
no. What
things, but I don't think it relates to when we're at the stage of counteroffer, offer, or rejection. I don't.
on the test they specifically say the moment that offer that came over to you is countered, the offer that was sent is terminated because you countered it. Now,
Okay.
now you become the offeror. Your offer comes over. If I change anything, that terminated your offer. Now my offer because you can't.
Okay. So
What the
they're
way that
saying that a rejection equates to a termination of
exactly
the previous agreement. And then that,
exactly
I mean, I would agree. Yeah.
the reason being is a safer instance. I send you back a counter offer. You never respond to it. So you go back to the email and you get that offer again and say, okay, well, I accept it and you sign it. No, you terminated it because you countered it the last. That's why I didn't respond to you. You know
Hmm.
what I'm saying? And or I didn't even that's what they're trying to show that if
Yeah, I
someone
mean, in the real world, that's not necessary. Like in the real world, but once we both sign the agreement, we have a valid contract. And you have to ask me if I want to change it. And I don't have to agree. And if I do not agree to your proposed changes, our agreement that we had signed still is upheld. Now, and if you do not abide by those terms, then you have breached. But I don't have to, after I've solidified that agreement, accept your new offer. So again, in the real world, I don't know in the test world how they're approaching it, but in the real world, that's I think how, as an attorney, we got an agreement. It's done. You can't force me to change it after we've entered into this agreement. But if the parties do, then it is terminated, the prior agreement. And now they have a new agreement, right? But right now we're talking about rejection. So rejection is like before we really have a valid contract, because we're still talking about offer and acceptance, right? But again, I don't know how they test on that. I
I'm gonna
think
well
we're
what I
not
what I
yet at a valid contract.
what I'll do, class, and I'm gonna send you the question or the questions is I'll show you the question that I'm talking about to convey what it is.
Send it now so maybe we can,
Well, go ahead. Here, do you want the next slide?
no, I wasn't done with this one.
Okay, go ahead. Go ahead.
Um,
I'll find it.
Okay, this is just an example of I think kind of what Han is talking about. So if the buyer and seller sign a purchase agreement, during the transaction, the buyer completes an inspection and finds defects that were not disclosed. The buyer can send a counter offer to reduce the purchase price, request a discount, or continue with the deal with the defects. In most instances, people will use the inspection period to request a discount, but when the counter offer to change the purchase price or obtain a discount for the repairs is sent to the seller, this is considered a counter offer to the original purchase agreement. And the seller can accept the counter offer, reject the counter offer, or make another offer. And of course, if they reject the counter offer, if they accept it, they've terminated the previous agreement. And then they've started a new agreement on the new terms if they accept the new offer that was the counter offer. So I think in essence, that's kind of what we're talking about. Again, if you reject it once you have a valid contract, it is a termination because you have a valid
What I'm
contract.
talking about is not when you have a valid contract.
Oh, okay.
I'll show you exactly what I'm talking about, but go ahead.
Okay, we can go to the next slide. Okay, consideration. So we're off of offer and acceptance. Again, those are the first elements of a contract, offer and acceptance. Then there's consideration. Consideration is the legal purpose of an agreement. It's the mutual exchange between the parties that signifies that each party has incurred some form of detriment or has promised to do so, which legally binds them to the agreement. Where there is no consideration, then the exchange is considered a gift, because essentially there is no bargain for exchange. Consideration is essential to enforcing a contract. A test note, in the context of contract law, consideration refers to the following. Again, as stated above, something of value exchanged is the correct definition of consideration within the context of contract law. This can include the price that one party pays. However, consideration is not always monetary, but must be something of legal value. So I don't know if you want to expound on that or not. I mean, consideration, although you can expound on it, I think it's really simple. Like in most purchase agreements, it's the purchase price. I agree to pay you $100,000 if you sell me your house. Me selling you my house is what I'm giving. You giving me the $100,000 is what I'm getting. And if there is no exchange, no detriment to one party, benefit to another, and if you see that on the test, I guess this is how they test it again with our test note here. They may just want to see that you understand what consideration is. So again, I don't want to know if you want to expound on that more, but
We're gonna really hammer like all of the key components to a contract. In the last slide, it was about counter offer and countering and stuff. So that's a secondary thing, but we are really going to hammer all of the things that create a valid contract. So, no, I'm good to go. Next slide.
yes.
All right.
Okay, legal purpose. I didn't spend too much time on this because it's really self-explanatory. Um, the contract can't be for an illegal purpose, therefore it must be for a legal purpose. I mean, you can't, there is no valid contract to do anything illegal. If you're contracting to do anything illegal, the contract is just void. That's, I mean, obviously, in the context of real estate, I doubt anyone would do this. Well, let's take a step back. A lot of people commit money laundering and mortgage fraud and those sorts of things in the transacting of real estate. So again, whenever your intention is illegal, the transaction is void. So every contract must have a legal purpose to be a valid contract. We can go to the next slide. Competent parties. This is, I think, again, one that we didn't want to spend a lot of time on because it's just straight to the point. You have to be competent to contract. Therefore, people have to have legal capacity. They cannot have dementia, be incapacitated, be a minor, or in any way, shape, or form, not be able to have an intent to enter into that agreement, formulate an intent to enter into the agreement. So again, competent party. So just to review, as Hans stated, for you guys' purposes, there are four elements to a valid contract: offer and acceptance, consideration, legal purpose, and competent parties. So with that, we can move to the next slide.
And so I know what the next slide is because I can see it. For the test, know the definitions of everything that we just went over. I wrote it down: offeror, offeree, delivery, acceptance, understanding the mailbox rule, counter offers and rejection. We touched on executory contracts, but I don't think that it was just mentioned in the words.
We're going to touch on that later
Later,
in
okay.
more
So
detail.
so contracts is short, but you got to know everything in contracts because they're going to test. It's going to probably be one or two questions about every little subsection that we're going to go over. So know everything that we've cut. Know everything that we covered, and this is how we'll use the metric. If you don't know it, don't go take the test. All right. Because you need to know all of the things that make the contract valid, and that's just what we went over, right? Moving on to the next slide. There you go.
Okay, statute of frauds. The statute of frauds is just a body of law that requires certain contracts to be in writing. I think for there are several contracts stated in the Ohio Revised Code that must be in writing, but for purposes of real estate, we're going to focus on two types of contracts. Of course, contracts for the sale of real estate, all contracts for the sale of land, real estate have to be in writing. And any contract that can't be fulfilled in a year, such as like your short-term lease, well, your long-term leases, those sorts of things, they have to be in writing. There are some contracts like short-term leases, month-to-month leases, those can be oral. But again, understanding those two rules will help us to understand what needs to be in writing when we're dealing with our real estate transactions. So a test point.
For the test, we're going to use verbal and not oral. Okay.
Okay.
All right. So we're going to use verbal. They can be verbally, they can be verbal. One thing about the statute of frauds, Jazz, I can't remember, I don't know if you'll remember it, but you said something about the exception, the 1 year lease. Why isn't that required to be in writing, you think? Anything shorter than a 1 year lease. Why do you think that's not? I don't know. I truly don't know this. I'm not saying it trying to get you to say it for the class. You said something and it just didn't stick with me.
What you said, short-term leases don't have to be in writing. Why?
Yeah, why do you think that is?
Because they're leases for less than 1 year. They're not for the sale of land. So all contracts for the sale of land have to be in writing. Again, sale. The statute specifically says the word sale. It does
Well,
not
why do
say
leases over 1 year have to be in writing?
because all contracts that cannot be performed or fulfilled in a year must be in writing. So any lease agreement that is a year or more cannot be fulfilled in a year. Therefore, it must be in writing pursuant to the statute of frauds. So again, those are the two rules I think most important in real estate. The other ones are the for the repayment of debt of another, which in some instances can relate, but I don't think it's going to be on your test. But that's another one that has to be in writing that may relate to real estate. Again, if somebody got a debt for you and you promise to repay their debt, then theoretically that has to be in writing, although there's some exceptions to that. I just had the case.
So statute of frauds, these contracts that we are getting into, or pretty much all real estate contracts should be in writing unless it's a lease for less than 1 year.
I would say all contracts should be in writing, and we'll talk a little. We're gonna get,
No,
there's
specifically for the test, we're just doing a real estate test. So
okay, yeah, yeah.
so
I mean, but here's a test point from the things that you gave me. If you read this, it's going to go into some of the things you're talking about, like why other than the rules, what is the reason why people want to have something in writing? What's the benefit to it, right? And this test point you sent over, I think, describes the why, but go ahead.
it says if an agreement is not in writing, then generally speaking, it is unenforceable. An agreement that is in writing but lacks the essential terms of the agreement is not enforceable. The essential terms of a real estate contract will include name of the parties involved, the description of the property, a purchase price, and closing date. A written contract provides a tangible record that can be referred to in this case or referred to in case of disputes, misunderstanding, or if one party attempts to renege on their obligations. It serves as a protective measure for all parties involved, ensuring that the agreement is clear, understood, and agreed upon by everyone. This requirement helps maintain the integrity and trust in real estate transactions, which are often complex and involve significant financial commitments. Okay, so that's why they want it in writing for all of those reasons there. So know the statute of frauds for the test. That's a definition question. They're gonna come at you at all angles, but know that the statute of frauds says all real estate contracts. Yeah, I say all contracts, but the test says all real estate contracts have to be in writing to be enforceable. Right? We're gonna go to the next one. Okay, go ahead.
All right. So, again, we just talked about written and verbal agreements. Um, some Most of the time, our written agreements are going to be our express agreements, for the most part, unless there's something in there that causes them to not be valid, and then we'll have to imply a contract. But nonetheless, there are two types of contracts. Express, which is a contract where the terms are expressed, they are specified, and it shows the intention of the parties. Typically, these are written agreements. An implied agreement is one that is demonstrated by the actions of the parties. And again, like I stated, usually where either there is no writing or the people necessarily didn't have an agreement or their written agreement somehow is defective, then we'll still imply a contract where the parties' actions demonstrate that an agreement exists between them. And again, implied contracts are usually our verbal agreements. And the problem, though, with verbal agreements, to juxtapose that to written agreements, is that here it's very much, more uncertain about the terms. It's less likely for people to be successful in litigation. So where a written agreement is important and the positive things about a written agreement, those things are going to be the negative parts of not having it in writing. So again, I think all contracts should be in writing, but the statute of frauds say all contracts that are for the sale of real estate and 1 year and other things need to be in writing. But I would just err on the side of caution. However, for the test purposes, again, like Hans said, whenever you're seeing a test showing you that something wasn't in writing, you probably are being shown a question about statute of frauds issues. So we
This
can
is
go to
gonna be this is gonna come and hit you on the test just by knowing the definition. They may give you an example for implied, because here's the thing about implied. Express is so easy. It's in writing. It ain't nothing, it ain't really no other scenarios. Is it or isn't it in writing? The ambiguity comes into play when you're talking about an applied contract. So your express contract is going to be easy to answer the questions. I mean, because it's going to have to say that it was in writing in whatever question that they ask you. So boom, as soon as they say it's in writing, you know it's an express contract or explicit contract. Like I said, the trick comes in with an implied contract. And the way that they're going to ask it on the test is that by someone's actions, or it won't say that it's in writing. So a lot of times, this is a definition question, and the only one that you can really get tripped up on is the implied contract. But just know the definitions of these. All right, know the definitions of these, because it's not really going to come at you in a whole like some weird way on the test. You just know, if you know the definition of these, you're going to do well on the test. Is pretty much what I'm saying if they ask you a question about either one of these. All right, go ahead.
Okay, so our next topic is like four different terms all together, but they all relate. So I put them all together. So we have valid, void, voidable, and unenforceable contracts. So the first is a valid contract. A valid contract complies with the statute of frauds. It has all the essential elements of a valid contract being offer, acceptance, consideration, legal purpose, and competent parties. A valid contract is legally binding and enforceable in a court of law. A valid purchase agreement will create in the buyer an equitable interest in the subject property. And I just threw that in there. I mean, didn't really know where else to throw in that an equitable interest is created with a valid purchase agreement, except where we talk about valid agreements. But I don't know if this is on your test. However, I think when we're talking about purchase agreements, that's not somebody buying a house. That's somebody agreeing that they will buy a house. That's someone agreeing that they will sell a house. We'll get again more into executory contracts, but what's created in the buyer is an equitable interest in the subject property. So if that comes up on the test, again,
The
that's what.
way I marry this to the test is in the assignment section. You see what I'm saying with the equitable interest? Because that equitable interest gives you the right to assign the contract to someone through your equitable interest. No, that's going to be a definition that we need to know, though. Equitable interest. Another place where I bring this in, Jazz, is in property rights.
Mhm.
Because in the sense that equitable interest creates a lien on the property.
Oh yeah, yeah,
You know what
yeah,
I'm
yeah,
saying? You
yeah.
so I bring it in property rights too, because it acts and affects like the property like it's a lien until it's released.
Mm-hmm,
You see what I'm
mm-hmm.
saying? So I don't. It's a definition that we really gonna need to know. Pretty much what it's saying, y'all, to keep it in layman's term is if I offer to buy Jazmine's house and she accepts, she can't sell it to anyone else until either I breach or we mutually agree to sever ties. Right? Here's the key: as long as I myself as the buyer performs, I'm gonna get that house because she agreed to it. Right? Now, what I'm gonna do, and we probably will talk about this later, if she reneges on selling me the house, I'm probably gonna have to take her to court. But when she enters into that contract with me and I perform as the buyer, 90%, 95, a high percentage, I'm gonna get the house if I perform. Period. If I do everything that I say I'm gonna do in that contract as the buyer, I'm probably gonna get that house. Or I'm gonna try, and I don't know if you agree totally with that, but if you can see what I'm saying, because when me and Jasmine when she agrees to sell me that house, I told her I'm going to do XYZ to get it. If I do XYZ, it's mine.
Yeah, I also think, I know this is so far off of what you guys will be tested about, but as an attorney, you always have to be a proper party of interest to bring a claim. And I think if we look at it, the buyer is not the owner until they actually own it. But this agreement gives them some interest in the property that they don't even own yet, the interest to buy it. And so again, it's an equitable interest. No, they don't own it, but they have a right to say that they can buy it. And again, like Han said, to the exclusion of anyone else, because they have a valid agreement that says they can buy it. So,
And it encumbers the property. I mean, encumbers means it's a cloud. It
yeah,
encumbers the property because you can't, you just locked yourself into an agreement and you can't sell it to anybody else unless we mutually agree that I'm not the buyer anymore. We're
yeah.
gonna talk about
It's
that a
become
lot.
very litigious too. Like people
Yeah,
file
yeah.
affidavit of facts, it's a lot. It's a
Th-
very litigious.
That's another just definition question because it begins to get really technical. They just want you to know the surface stuff about equitable interest. And really all I would remember for the test is that when two people enter into a purchase agreement, this is for the test. When two people enter into a purchase agreement, the buyer has equitable interest. Now that person has interest in that property because if they perform, it's their property. All right. And that seller, once that seller signs that contract, they cannot legally sell it to anybody else until me and that other person agree to eat. They can't sell. If I perform, it's done, it's executed, it's over. If I breach, then now I breached. So I didn't perform my agreement the way that I said it. So now they can get out because of that. But if I do everything that I said I was going to do when we went into contract, it's likely that that's I'm going to get the house. It's likely. All right. So equitable interest is just a definition question, but it's a vague question and it's hard to explain. Even with this discussion and back and forth, it's hard for people to really get the concept of what equitable interest is. But for the test, what you really want to know is that when a purchaser or a buyer gets an offer accepted from the seller, they have what they call equitable interest in that property now. And that does not go away unless it's mutually accepted or you breach or mutually agreed that we're going to sever the relationship or that buyer breaches. All right. That's what we need to know for the test. I'm sorry. Go ahead, Jazz.
No, it's fine. All right. So now that we've established that we have a valid contract, what a valid contract is, the next term we want to really focus on is void, void contracts. A void contract has no legal effect. It lacks, in contrast to a valid contract, a void contract lacks the essential elements of a valid contract and is as if the agreement never existed. So, again, a contract that's for an illegal purpose, not only does it lack the essential elements of a valid contract, again, because it's not for a legal purpose, but also any contract for an illegal purpose is just void. And in the law, what we call ab initio, from the beginning, is just void. You cannot move forward with this contract. It has no legal effect. It's again as if it never happened. So again, that's void contracts. I don't know if you want to expound on that any hand, but if not, we can go to the next slide.
Yeah.
All right. A little test point about void contracts. Um, What is true about void contracts? They lack legal effect from the beginning, is the correct answer because it accurately describes the nature of void contracts. From the moment of their creation, these contracts are deemed to have no legal effect. This means that the agreements do not create any legal obligations for the parties involved, and they cannot be enforced by a court of law. The reason for this is that void contracts are fundamentally flawed due to reasons such as illegality, lack of capacity by one of the parties, or the absence of a mutual agreement. For example, a contract to sell a house in exchange for illegal drugs, which I don't know how often that happens, or to launder money, which could happen through, say, like a mortgage fraud or a void transaction. This is a void transaction from the offset because, again, it violates the law. So, um, don't need to spend a whole lot of time on that. Void contracts, they lack the essential elements of a valid contract. And for the most part, these are contracts that for illegal purposes. So, in comparison, a valid contract is, the opposite of a void contract. And again, you'll, I want to go to the
Can you
next slide
kind of
to talk about voidable,
can you
huh?
can you kind of have a valid contract?
Can you kind of have, yes, when we talk about voidable,
Okay.
good access
I'm
from
talking
void.
about from the outset.
From the outset, I mean, everything in the law depends,
What I
and I'm
what what I mean by that is, I'll
okay,
give you an example. Really,
okay,
all you want to do for the test is this. This is what I tell them. Is missing one of those things that make a valid contract.
okay,
Hey,
okay,
hey, I got what I got competent parties, I got legal purpose, I got offered acceptance, right? Well, I'm missing something. I'm missing competent parties. Well, grandma she kind of cognitive. Either she is or she ain't. You see what I'm saying when I say kind of? Either she is or she ain't. If you're missing one of the tenets of a valid contract, it don't matter which one you're missing. You do not. It's void. It ain't kind of valid. It ain't. It ain't. Maybe it's valid. It's either valid or it isn't from the start, right? Which means that you're missing. Okay, so let's do this. We got competent parties. We got legal purpose. We got offer and acceptance. Well, we don't got no consideration. That's void. It's missing one of them or two of them, or it can be missing. It can be missing more than one of them. But of those five things that Jazz went over, offer and acceptance, we know them. We should know them by now. Offer and acceptance, consideration, legal purpose, competent parties. If any one of those is missing, void. So where you are going to get test on the question on the test at is that they're going to say, this is what I do. As soon as I hear something, as soon as I look at the question and I see it, let's say for instance, is this contract valid? You just got to read the question. I look at the answers and I'm looking for one of those five things. That's what I'm doing because I know if one of those, in other words, one of those things that make a contract valid. If it's missing, it's void. It's not voidable. It's not counter valid. It ain't nothing. If it's missing one row, I can't harp on this enough because if you can remember this and really implement it into your studies, you're going to probably get about 3 or 4 questions right just because of it. Because what they're going to this is what they're going to test you on the test too. They're not going to test you if you know what a valid contract is. There might be one question about that. They're not going to test you on what a void contract is. It might be 1 or 2 questions on that. They want to know if you know when a contract is voidable, because that's when the game begins. A valid contract has all of them. A void contract is missing one of them. How hard is that? And that's why I tell you, I don't like telling people this, but if you ever have to choose on a test question and the answers are valid, void, or voidable, choose voidable because you should know what a valid contract is and you should know what a void contract is. The ambiguity and the confusion comes in when it's voidable. And with that being said, I know you said move to the next slide, so that's what I'm gonna do. But we're hammering this because this is the essence of contract on the test. Period. This right here is some you probably will be asked 6 to 7 questions just about valid, void, and voidable, maybe more.
All right. So, as Hans stated, the gray area is a voidable contract because here you have some that appear to be valid, but for some reason, one or the other parties can void it after the fact. So I think what's important to understand the difference in void avoidable is always about sequence of events, So what'll happen first? The contract is either valid or void right from the beginning. If you have a void contract, you don't get to voidable, okay? Because it's void, again, ab initio, right off the bat. A valid contract is a valid contract, but that's where, again, we get into the gray area, avoidable. So, avoidable contract appears valid, but may be disaffirmed or voided by one party based on some legal principle. So, again, we're past the fact that, we have what we think is a valid contract. So we know it's not void because we wouldn't even think we got a valid contract. But we think we have a valid contract, and then some things had happened or will happen or did happen that causes it to be voidable. And these are some of those things. Undue influence or overreaching. Here we have like a power struggle. We have one party that's, either, I don't know, typically we see these in fiduciary relationships where one person is obligated to look out for the other person and they do something maybe self-serving or things like that. Or maybe, it's someone that just has I think I don't know, maybe in relationships where you have like a bullied person and they're making someone do something that they don't want to do. That's where you have overreach and undue influence. And if a person doesn't really want to do something, but somebody makes them do it kind of against their will, but not like a gun to their head or something, then we have undue influence or overreaching. I mean, a gun to your head would be a criminal act, but it would still fall under undue influence or overreaching. I think that's a little far-fetched. I doubt that would ever be on your test. But again,
Actually they do talk about undue influence on the test.
okay. They don't have somebody putting a gun in somebody's head though.
Yeah. There was an example of something like that
Uh,
where you're made to. It's called duress, and it goes
okay.
to the good faith
Okay.
mode.
You know what? I didn't put duress in here, but I'm glad you
But
brought that
that it
up.
goes to that. So, but it's not.
Yeah,
It's not.
duress, I think, is much different than undue influence or
But
overreaching.
we won't. We
Duress,
won't. We won't see a lot of that.
yeah.
The voidable stuff, and you did this in the last class, is really going to come into play where you have a valid contract, and then something subsequent to that caused it to be voidable or gave one of the parties to be voidable. Not necessarily that it's voidable. Something like that would have to be voidable from the beginning. Like I made you sign a contract with a gun to your head. That's not really going to be on the test.
That
What
would probably be illegal, but
what
none.
really what really is going to be on the test is misrepresentation. Like I didn't tell you about a leaky basement. Now it's voidable, or something changed, or something happened with the property. right?
So
So that
mostly
makes it
fraud
avoidable.
is what they're testing voidable.
Exactly. And
Okay.
misrepresentation.
So, getting into that, I have a lot of litigation experience in the area of real estate fraud. And so I would say that real estate fraud does encompass two major topics, which is misrepresentation and active concealment. So, what is fraud? Fraud is knowingly making a false statement or making a statement that one is recklessly disregarding the truthfulness of a statement. And then there has to be some injury to the person that justifiably relies on that statement. And the reason I bring up, and I don't know if they test on this, but justifiable reliance goes to the injured party's duty to get an inspection, to caveat emptor, buyer beware. So you can unjustifiably rely on someone's misrepresentation. And that would be, say, we're standing together looking at something. It's clear as day that it's defective. Me lying to you and telling you it's not defective does not negate the fact that you have to be on notice of things that are open and obvious. You have to get a reasonable inspection. So you can't just blindly rely on everything I say and then help me responsible later. But again, in the context of void and voidable, we're past that we think we have a valid contract. Something happens subsequent to that that causes one to want to void the contract. And one of those things could be fraud. If you truly misrepresented something to me, which is lying about the condition, or just anything where you lie about something. I don't know if they get into negligent misrepresentation and knowing misrepresentation, but
Intentional and unintentional misrepresentation.
okay.
Intentional and unintentional fraud, and then um, it's intentional or unintentional fraud by the agent, but that doesn't come in here. That comes in disclosures.
Okay.
Yeah.
So
So we're gonna go over it, but it's not part of contract.
okay, just in
More of the,
context,
that's more
avoidable.
disclosure. Yeah.
Okay. So again, just in the context of avoidable, whenever you see a situation where you have someone lying about one of the essential terms of the agreement, one of the essential terms, material terms of the agreement, then that is misrepresentation. Of course, active concealment is exactly what it sounds like. You are actively concealing something. You're doing something to hide something. And this is typically, I mean, you find this where there's some leaks and people will paint over it. Or there's a basement issue, and rather than cure it, they'll just clean it up and put new carpet and hope that it doesn't leak before they sell it. These are acts of active concealment. I did definitely sue somebody. And, I ended up getting a judgment of like $50,000 for my client because these people did basement waterproofing, but what the real problem was that there was a sub pump, actually not a sub pump, I'm sorry. It was a pipe that caused the water to come into the house rather than divert away from the house. And they knew about it. It was stuff with the city. But rather than tell the buyer, they tried to do some quick repairs and hope that it didn't come up, but it did. Their basement flooded, their backyard flooded, and these people are held responsible. But part of the defense of the other side was caveat emptor, buyer beware. This guy got a reasonable inspection and it showed that there was moisture in certain areas. So again, active concealment as it relates to voidable and being able to void a contract. If someone actively conceals a condition, you can void that contract. Um,
Well, look,
an
no,
example. Oh, go
no,
ahead.
hold on. Let me say this. In the material fact is how you're going to see it on the test. Something or some sort of information that would have altered a person's decision to do or not to do something. That's the material factor and where how it's going to come in on the test. So it's called material fact on the test. And a few times before, and now they you may see this on the state exam. But we talked about suicide or death or something heinous that happened in the house. By Ohio law, you don't have to disclose that. But that could be considered, and people have been sued because you concealed the material fact about the property. Maybe, bodily fluids were, I don't know. But that's how they teach it on the test. They go at it under material fact on the test, and you just need to know the definition of what material fact is. And again, it's information that, if known, it would have caused somebody to, if that information was known, it would have caused somebody to not do something or do something. And that's the disclosure of material fact. So that's how it's going to come in on the test. So just know
So,
the definition of material fact. Go ahead. My bad.
no, you're fine. I didn't put this in there in the definition of fraud, but again, the fraud has to be related to a material fact, as Hannah stated. So, getting more into voidable, we talked about fraud, like in some instances of fraud that will require a contract to be, allow a contract to be voidable, again, undue influence, overreaching, and duress. But sometimes it's not any of those things. It's just that something changed subsequent to a valid contract being created that would allow one to leave the agreement. And an example of that, where again, there's no fraud, there's no undue influence, but something changed after that valid agreement, is where, say, for instance, the buyer requests the seller to leave the appliances in the property, which I think most time you have um, instances where there's personal property in the real property. And as a part of the agreement to purchase the home, the buyer will ask that that personal property remain. Well, if they do their final walkthrough and they find that that personal property has been removed, that's a voidable situation. Because again, we had a valid contract, everything was going fine. And we had an agreement that you would leave this personal property, but then you removed it. I can void that contract now because something changed after we had a valid contract. So that's an instance again where there's not necessarily any wrongdoing on one party's part, but something changed subsequent to the valid agreement that allowed one of the persons to disaffirm or void the agreement. So I don't know if you want to add anything to that. Otherwise, we can go to the next slide.
Okay.
Okay, again, more about valid, void, voidable, unenforceable contracts. So, what is an unenforceable contract? Again, don't need to spend a lot of time defining this. An unenforceable contract is a contract that no party may sue to enforce the other to perform. And an unenforceable contract is usually one that's not in writing, because again, the statute of frauds requires these contracts to be in writing. These
And then
being
again,
the
yeah,
statute of frauds requires real estate contracts to be in writing, contracts for the seller real estate. And if it's not in writing, then that contract is unenforceable. It's not enforced in a court of law. You can't sue anyone to enforce their performance on the contract.
an
And that's
unenforceable contract is usually one that's not in writing. That's where they're going to test you at on. That's how they're going to test you on the test. And it typically is going to ask you about. They're going to explain like, okay, Mary and Sue verbally agreed on something, and they'll give you a scenario. When soon the key to it is verbally or that is not in writing, right? And that's what makes it. That's typically what makes it unenforceable. If you can remember that, like write that down. Typically, unenforceable contracts are not ones that are not what express contracts, because we know express contracts are contracts in writing. Like, unenforceable contracts are usually ones that are not in writing. Remember that for the test. Go ahead.
okay. So also, unenforceable is sort of hand in hand with void, right? Because this is a test point provided by hand from, I'm assuming, your test. And what this says is that a real estate contract is which one Wait, let's start over. A real estate contract in which one party agrees to sell a property without receiving anything in return is generally an unenforceable contract. While it may meet the basic elements of a contract, it cannot be enforced in a court of law, because there is no consideration. This person is selling it without receiving anything in return. And the absence of that consideration renders the contract unenforceable. So again, where we had a void contract that was void because it lacked one of the essential elements of a contract, a void contract is also unenforceable. You can't go on a court and sue on it or enforce someone to perform the terms of an unenforceable contract. So um, we can go on to the next slide. I don't know if you want to add anything to that,
No,
but
I'm okay. I'm okay on that one. Hold on.
oh, okay.
No, no unenforceable contract. I would know everything on these slides, honestly, and it's a lot, but it's all in this. It's all these are all definitions. But go ahead.
Okay. So now that we've established again what it requires, what is required to have a valid contract, um, we may want to talk about, not just what'll require us to look at a contract being valid, void, and voidable or unenforceable, but we have a valid contract. Everything is going well, and then somebody doesn't perform. So that's where we are now. We're talking about breach of contract. And what are our remedies if a person just flat out fails to perform? So a breach of contract is where there is a duty to perform and a party fails to perform their duty as per the agreement without legal justification. An agreement that was breached is voidable by the non-breaching party. Some of the remedies for breach of contract, one is rescission. Rescission. An injured party may rescind a contract, causing the contract to have to be unenforceable. And that's pretty much as if the contract never occurred. Any monies, though, that have been exchanged must be returned when a party is intending to rescind, unless the party agrees otherwise. So, for an example, I don't want to get into this. The next slide talks about this, but when we're talking about returning the money, that's typically where there's monies in escrow that would have gone to, say, the seller and say the buyer defaults. Well, the seller would have to return the money unless the parties agree otherwise in order for the seller to have that contract not be enforceable because of the buyer's breach. But there are tons of instances, again, where you'll probably keep the money in escrow. But again, for purposes of the test, I think we need to understand that when we rescind the agreement, we have to return the consideration that may have been given in order for that rescission to be effective. A test point here, a buyer enters into a contract for a residence. After the inspection, it's discovered that the seller knowingly emitted significant foundation issues or committed knowing misrepresentation or real estate fraud. What is the most appropriate action for the buyer? Rescinding the contract is the most appropriate action for the buyer under these circumstances. Rescission is a remedy that nullifies the contract, returning both parties to their pre-contractual state as if the contract had never been made. This action is justified when there has been a significant misrepresentation or omission that goes to the heart of the contract, such as knowingly hiding major defects like foundation issues. Rescission is particularly suitable here because it addresses the breach's fundamental nature, allowing the buyer to walk away from a contract that was entered into under false pretenses. So again, one of the remedies for breach of contract is going to be rescission. I don't know if you want to expound on that. We can go to the next
That's
slide.
good. That's clear and concise. That's good. Okay.
All right. More remedies for breach of contract. Mutual release. This you'll see a lot, a lot. Whenever you are in your position as a real estate agent and the deal does not go as planned and the parties want to walk away, please make sure you have a written mutual release. And here's some of the reasons why a mutual release is something that you may use in a situation where there's a breach of contract. So the parties may mutually agree to rescind the contract. So a rescission we talked about before is an idea. And in that instance, maybe it's one party who was wronged rescinding, but here we're talking about a mutual release where the parties together agree that they're going to rescind the contract. Um, Here, where one or the other parties have breached again, there may be a mutual rescission or release. As an agent, it is best practice to obtain a written mutual release when the parties mutually agree to cancel the contract. Not only will a mutual release free the seller to accept another offer. Again, they're under contract until they're not. As we were talking about earlier, termination of the agreement will have to occur in order for that seller to be able to sell their house to someone else. Otherwise, that buyer still has an executory interest. So the release pretty much is the written agreement that the parties no longer agree to move forward. And it cancels the contract. So not only again with a mutual release, free up the seller to sell to whomever else other than this breaching buyer, but it will also make sure that in the future, the parties don't come after each other for that breach. If we mutual release each other, we're saying that we're walking our separate ways and we're never going to come after each other in the future. If you don't have a mutual release, somebody could still sue the other party. So again, best practices is to have that in writing.
Now,
Also, if
now let me add something real quick to that. You can in the real estate, you're likely to have three ways it'll go, and this will be on the test. A mutual release with the earnest money going back because it's probably going to be some sort of liquidating damages or earnest money, earnest money associated with it. Remember, earnest money is the money that's pledged to show you that I'm serious. But that mutual release has to guide the title company if the money, earnest money, have been deposited. All right. What I mean by that is that there's types of mutual releases. It'll be a mutual release funds going to the buyer or mutual release funds going to the seller. Depends on who's the breaching party. All right. And they have to agree to that. Because this, and we'll get into earnest money, I'm probably pretty sure, but I just wanted to, for the test, the mutual release is an agreement between the parties to sever, to get out of the contract, but there's still another component to that, and that's directing the earnest money where to be sent if earnest money is involved. That's all I wanted to add for the test. Go ahead.
okay,
I think you were about to read something.
okay.
Termination. Go ahead.
Yes. Termination, again, just I think that's a really easy one to understand. The injured party may cancel or terminate an agreement that is breached. And, you know, in all instances where we have a contract that's signed, I don't care what type of way in which it's ended, unless you're going to go into court, everything should be in writing. So the termination, all of that, it should be in writing. But again, an injured party may choose as one of their remedies for a breach of contract to terminate the agreement. Also, another way a agreement is terminated is by operation of law. In this instance, whatever laws in place um, will cause the contract to be void. For instance, minors can't contract. So that law is by operation of law going to cause the contract to be void and terminated, or this is a remedy. I think, when we're talking about minors, I don't know if you're going to get tested on this, but there is a theory that they can ratify the contract later, that if they breach, they are not necessarily held responsible for their breach, but the adult they can hold responsible. I think when we're talking about real estate, when you're on the test, whenever you see the idea of minors being involved, that probably is just a void contract that, you know, just is not enforceable. But again, by operation of law, some contracts can be breached or not valid or not enforceable. Other remedies for breach of contract, specific performance. This is very much a thing for real estate. Specific performance as a remedy in general and contract law is something very specific to real estate. And the reason being is that real estate is unique. So the remedy of specific performance is only offered where the thing that we are arguing about is unique. There are some goods that are unique, some heirlooms, those sort of things, but real estate is always unique. I don't care if you got twin houses, they're on a different lot. So specific performance is always offered as a remedy for a breach of contract. But it's not offered typically to the buyer. Like usually you would sue the buyer for monetary damages for not buying the house. But it's usually the buyer that's suing the seller to have them mandated to sell their house against specific performance. So specific performance is a remedy. It'll come up typically when you're looking at remedies for the buyer against the seller. So a test point, if the buyer fails to complete the purchase of a property as agreed in the purchase contract, what is the likely remedy for the seller? Specific performance is the correct answer. Specific performance is a remedy for breach of a real estate contract because real estate is unique. It cannot be duplicated or replaced, and monetary compensation may not be sufficient as a remedy for the harm caused by the breach of the seller not selling the buyer the house. So I don't know if you want to expound more on any of these
This
topics
is
for
the
remedy.
only thing that I'll say is a couple of things, and you should write these in your notes. When you hear remedy, legal remedy, they probably talking about specific performance because there's not a whole other lot of legal remedies for either party other than specific performance. A remedy is all is on. Think of a remedy as a fix. It's not saying that it will be fixed, but it's a remedy. What I mean by that, you'll read a question. Where's the test question here?
If the buyer fails to complete the purchase of a property as agreed in the purchase contract, what is the most likely legal remedy for the
Specific
seller?
performance. As soon as you hear remedy,
Well,
specific.
and I don't know this is
I'm
not right.
just, I'm just, I'm just showing. I'm just. The question is all I need.
Yeah, the
As soon
question
as you
seems
hear,
to be I didn't type this, I copied and pasted this, but it should say if the seller fails to complete the purchase of an agreement,
right,
then
right.
the
I
buyer's
agree.
remedy is specific performance, making the seller specifically
I
perform.
noticed that too in the
Seller.
question. I noticed that too in the question, and that's you didn't type it wrong. That was a copy and paste, and I noticed that too. So
Sure.
what they're saying is that the buyer will have specific performance on the seller. The seller would hardly ever go for specific performance against a buyer. All right.
Yeah, but they could, and they would just be asking for the purchase price, which is theoretically monetary damages. Therefore, it's not specific performance, right?
But all I want y'all to understand for the test, know the definition of specific performance. And when you hear legal remedy, they're like, it's not going to be any other answer that they're going to say legal remedy. It's going, if you hear legal remedy or remedy in court or something like that, it's specific performance. These are the type of questions that people have been getting wrong on the test. And we need that point. We need that question towards the 56. We should not get any definition questions wrong. This is one of them. You might get just one question, but we got to get that question. So no specific performance because it's too easy not to. All right. All right, go ahead.
All right. Again, more remedies for breach of contract. As we were discussing, monetary damages. This is again where, if you sue, you're just asking for money. You're not asking for a specific performance. And typically monetary damages, unless people go into court, are liquidated damages that are already outlined in the contract. And this is typically your earnest money deposit. What is liquidated damages? Liquidated damages are intended to provide a predetermined amount to fairly compensate the injured party for damages where the amount of damages may not be easily quantifiable. So, if that were the case, they just go into court. But usually, again, you'll have an earnest money deposit, and parties are typically going to look at that earnest money as the remedy for the breach of the purchase agreement, and they're going to look at that as liquidated damages, again, already kind of predetermined in the agreement. A test point: if one party breaches a real estate contract, they may be required to pay liquidated damages, is a correct answer. Liquidated damages offer a predetermined resolution that both parties have deemed reasonable and equitable at the time of the contract's formation. This pre-agreement on damage is particularly useful in real estate contracts due to the unique nature of property and the potential for significant financial loss. It simplifies the process of resolving disputes and provides a deterrent against breach, ensuring that parties are more likely to fulfill their contractual obligations. So I don't know if you want to talk more about liquidated damages, but
Uh-uh. It's not one of those key. It's not a real thick part of that meat and potatoes that we need to know. Just know the definitions on it.
okay. All right. Again, more about this topic. We talked a little bit about earnest money, but just to give you guys more meat on the definition of earnest money, it is money that is pledged as good faith by the buyer to the seller that the buyer will perform on the promise to purchase. That is the purchase agreement. Typically, earnest money is considered liquidated damages in a real estate transaction where the buyer backs out of the deal without a valid reason as allowed by law or outlined in the contract. A test point: what is the purpose of earnest money in a real estate transaction? The correct understanding of earnest money's role is that it is intended to show the buyer's good faith and demonstrates to the seller that the buyer will perform and not back out without a valid reason. If the buyer does breach, the seller may have the right to keep the earnest money, which compensates for the time the property was off market and also referred to as liquidated damages. This financial commitment by the buyer helps to solidify the transaction, reducing the likelihood of the buyer withdrawing without cause. Another test point: what is a possible consequence of a breach of contract in real estate transactions? That is the forfeiture of the earnest money. This is a common consequence for a breach of a real estate transaction or purchase agreement. And we can move to the next slide.
Are y'all ready to go to the next slide?
Yes,
My bad. I had to run upstairs real quick. All right.
that's okay.
All right, there you go.
Okay. Assignment versus novation. I think a lot of us probably have heard the word assignment because so many people are wholesaling. So just briefly, an assignment is a transfer of rights or duties under a contract, generally to a third party, the assignee. If a contract is assigned, the assignor, the person who assigns the agreement, is still on the hook for the contract terms. Considering that wholesaling is a widely used real estate strategy, it is good to understand the consequences of an assignment in relation to the obligations of the contracting parties. A wholesaler will typically enter into an agreement to buy the seller's home and then assign the contract to a third party for an amount in excess of the purchase price, thereby allowing the wholesaler to make a profit by allowing someone else to buy the home. The wholesaler is still on the hook, though, for all contract terms if the wholesaler assigns the contract. So what that means is that, if, say, somebody breaches, and usually that would be the end buyer, if they breach and the wholesaler never had the money to buy it, they could still be on the hook to buy that house, even though whomever they were trying to wholesale it to didn't move forward. So the difference in an assignment through an ovation is that in an ovation, there's a substitution of a new contract for the existing contract. So in an ovation, there's a new party to the contract that replaces another party, and the new party is now liable, and the old party is released from liability. Um, Typically, Hans said that these are found in the finance section of your real estate exam. So what you need to understand though is where you
Yeah.
see an assignment, you'll see the same parties and I'm sorry, not the same parties, an assignment, you'll see a new party come in, but the old parties are still liable and still in the deal. Whereas with a novation, the new party comes in and one of the old parties is released or out of the deal. And so that is the difference again between the novation and assignment.
Know the definition of these. Know the definition of these. That's it. You might get one of these questions on the test. Now, novation is going to come in under finance, but I'm not even going to go into it right now. Just know the definition of assignment and know the definition of novation. I always like to do this for y'all because this is more than just taking a test for a class for the test. The fact that someone can assign a contract in a sense is going to be detrimental to your. It's going to be competition. I don't want to say detrimental because the wholesalers are competition for your for what you're doing, right? In a sense, they never had an intention on performing on that contract when they got under contract with that person. They don't have a license, so what they do is they create an equitable interest in the contract and in the property and sell that interest via an assignment. All right. And so this is a deeper it's for the test is not just know the definition, but in the real world, this happens all the time. All right. And as a realtor, you need to understand what an assignment is. All right. The other thing that and I always like to um have people that I know, I don't like saying students because we all the same, but I always like to have people that I'm going over this with understand why I think wholesaling isn't fair. In the last 2 weeks, we've been talking about agency, and we've been talking about these fiduciary duties that we are principled, loyalty, disclosure, um, confidentiality, accountability, reasonable care. All those things we owe them because we've entered in a contractual relationship with them. Yet a wholesaler doesn't owe that to the seller. The wholesaler got in the contract with no intentions other than to get that equitable interest and then try to sell that interest to somebody else. And it's in effect a listing agent, a quasi listing agent in a sense. They're looking for buyers just like you would have if you would have listed the property. Yet they don't have any of those fiduciary duties. And that's the problem that I have with wholesaling. They initially went in with no intentions to buy it, but to find buyers to buy it. Well, what in the hell is a listing agent doing? Yet they don't have those fiduciary duties that we as agents, and oftentimes they make more than the commission that we charge. That's the problem that I have with wholesaling. All right. If you want, like, because like real property, the couple of things I want to try to stick with y'all for the rest of your career. The two most important rights that you got of all rights is property rights and civil rights. Civil rights being first, property rights being second. Y'all are dealing with somebody's property rights. Y'all are taking property rights from one person on one side and transferring those rights to another person on another side, and you're the agent or facilitator, the enabler of that. And that's something that's like it should not be played with. I don't care if it's a house on 93rd or if a house in Hunting Valley. They all have something to do with property rights, and that's sacred, right? And so as long as you remember that, you will never be on this slick stuff that people, if you, long as you remember that, you will never be on this slick stuff that people be on out here with these properties. And if you know it, you're gonna be able to make like, if you know real estate, you ain't gonna never have to do nothing illegal. Period. You ain't gonna never have to do nothing shady. Only the people that, I mean, well, it's some shady people that know real estate that get over. But like, I just want to convey that to y'all. Like, this is more than like a just like a class where you come in and take the test. We're gonna pass the test. That's gonna go without saying. But what hopefully what leaves y'all from this class is something that y'all carry through y'all career. And if y'all carry those, y'all gonna be very successful because you're gonna strive to do things the right way. And you make money when you do things the right way. All right. So um on the test though, assignment and ovation are just simple definition questions. Create your note cards, walk around, ask questions about them. But the especially the assignment piece is much more prevalent in real life than what the test is going to emphasize. All right. All right, go ahead. My bad.
No, you're fine. You can go to the next slide.
Oh, you doubled that slide.
Oh, okay.
Okay, we'll take that. All right,
Era, last minute.
there you go. All right.
All right. Executed versus executory contracts can get a little tricky because we've heard the word, executed, like where people sign, but that's not what we're talking about here. An executed contract is considered a contract that has been fully performed. So all parties have fulfilled their promises. In the context of a real estate transaction, this is when the deed is transferred to the buyer. So again, once the deal is closed and the deed is transferred, that is an executed purchase agreement, not when two people sign it. They have to have fully performed. So pursuing, and this is just something I threw in. I don't know if this is on your test, but I think this comes up a lot. I just had a really litigious out of court situation where the two parties wanted to continue to argue about a contract that, I mean, the money was in escrow and everything, and we could not get these people to understand that nothing that they would do would change the fact that the deed was the most important document, not the purchase agreement, which had already been signed. So again, just getting into that, pursuant to the doctrine of merger, all terms of the purchase agreement merge with the deed upon closing. So once that purchase agreement has been fully executed, again, fully performed, all the terms of that purchase agreement are going to merge with the deed for the purposes of any disputes about the deal. So anything that you want to bring up about the purchase agreement, do it before you close. Because after you close, is fully executed, it's presumed the parties have performed. Unless, again, there's fraud and things like that, you can't sue just on a purchase agreement. I don't want to get too far into this. I'm sure Han will talk about this, but just to understand the idea again that once the deal is closed, the purchase agreement is fully executed, you don't go back to that to sue someone. You only look to your deed. So if your deed is a quitclaim deed, you can't sue for nothing, again, except fraud. If your deed is a limited warranty deed, then you may be able to sue the seller for any defects that were in title or other warranties. There are more than just title defect warranties. You can sue them in a limited warranty deed for the time they owned it. General warranty deed is just all the way back in time. There anything that is a warranty, they would have to warranty. But again, once the deal is closed, you can't go back to the purchase agreement. It is an executed contract, is fully performed. You will have to look to the deed as the place for your rights and responsibilities with that seller. Again, unless it's fraud. You can sue on fraud because that's your misrepresentation and act of concealment. Um, an executed contract is not to be confused with a contract that was signed, because a signed real estate contract is not an executed real estate contract until it has been fully performed. A contract signed by everyone is a valid executory contract. So an executory contract, not an executed contract, sorry. So if it's executed, fully performed, everybody's done. If it's executory, there's still some things we have to do. Parties have still some things that they have to perform.
That's the key right there. It's simple. Remember these definitions, we're kind of keep them down to about 5 to 7 words. Execute a contract, everything's done. Nothing else to perform. Executory contract, not everything done, still something else to perform or do. Just keep it that simple. Where they're going to try to trip you up on the test is, and because here's what you want. You want them to ask you as much as they can about objective things, definitions. So they're not really going to test you on the, like, you need to know what executory contract was. This is how they're going to trick you. These are trick questions. They're going to use the definition to try to trick you. Oh, you might see something like this. John and Mike executed a contract. Mike wanted to assign the contract that John and Mike executed. And then they're going to ask you questions. John cannot do this. John can assign the contract. This is a John can't do that. The contract executed. John, you can't assign something that's executed. It's done. It's final. It's over. If it was an exact, and that's how they're going to try to trick you on the test, right? That's how they're going to try to trick you on the test. They're going to say, John and Mike executed the contract. After the contract was executed, Mike wanted to assign it to a friend. How are you going to assign something that's been executed? But that will be a question on the test. Mike can assign it to John, no problem. Mike cannot assign the contract, and they'll give you answers. But if you know the definition of executed contract, you know you can't assign, a contract that's been completed. So I'm going to point these things out, and we're going to go over questions. But they're not just going to sit up and say, hey, Maria, hey, Jazmine, what's an executed contract? Y'all probably would have been, y'all probably would have been like, man, listen, this is easy. Everybody be telling you how easy their real estate exam is. So for these, just know the definition. So when we see the questions on our practice exams that we take, we know how to handle them and we can talk. What this is doing, y'all, honestly, we need to be able to talk the same language so you can learn it. Because if these definitions are foreign to you, I can't go but so far. So with the real estate, these are real estate terms, and what you're doing is learning real estate language. Because you're not going to be walking around, you might say executed contract or something like that, but you're not going to be talking to somebody like, man, that's a intentional misrepresentation and all. Like, people don't talk like that in the real world. But if you understand what the words are, you understand what we're going over, you then begin to be able to speak the language and at least able to interpret the language. And so all of this stuff that we went over today are going to be mostly definition things that now we can play around with them and fully understand what's going on with them. Sorry for interrupting.
No, you're fine. Um, yeah, I think you covered that. Our purchase agreements are executory contracts. And they're executed once the deed transfers. So we can go to the next slide on that one. All right. This is it. Here I just wanted to throw out just some different types of contracts. Again, we went over all of these different elements of contracts, some of the different ways in which that they are voidable, unenforceable, what happens if they're breached. But we kind of just talked really in the context of purchase agreements. Although they may be the most important because that's where you get your money, they are not the only contracts that you have to worry about. And you want to understand those things like your broker agreement. I mean, before you get into a relationship with them, there's could be some negotiations about your split and those sorts of things. So again, you'll have some offer and acceptance whenever there's negotiation. Of course, your agreements that you enter into with your clients, listing agreements, buyer agreements now, um, purchase option contracts, lease with options, escrow agreements. Again, these are mostly title companies holding the money, property management agreements. If you decide you want to manage properties, you definitely want to have that in writing. Again, leases, we talked about that. Some short-term leases don't have to be in writing, but I think they should be. And again, assignment and ovation agreements and finance agreements are just some of the other agreements that you'll run into. And that's it. I think the next slide is just Q&A, if there's any questions that you
Now,
guys want to.
now, thank you, Jazmine. Thank you, thank you. And I'm going to go into more thinking after I tie everything together. 2 weeks ago, we talked about agency. We talked about relationships. We talked about what I'm going to do for you and what you're going to do for me. That's the essence of a relationship. When we sign one of these, that creates fiduciary duties. That creates a client or a principal. That creates a fiduciary. A broker agreement is going to create, it's a special agency relationship because many things are going to be conducted there. I mean, I'm sorry, it's going to be a general agency relationship because many things are going to be conducted there. But the first relationship that you're going to enter into is going to be with your broker because you have to sign an employment agreement with that broker to spell out your compensation, to spell out what you're able to do on behalf of the broker and everything. You're going to spell out what again what your commissions are going to be, what fees are going to be applied when you sell a house, and what you're able to do. The next relationship that you'll get into is either going to be with a buyer or a seller, and that's going to be a fiduciary duty, and that's created with the listing agreement or contract, purchase agreements. All of these things here is what create that fiduciary relationship. You do not have a fiduciary relationship with somebody, or you can through implied actions. You could have it might not be enforceable, but you could have through implied actions, you could be acting like somebody's realtor. We went over that stuff. But these are the expressed documents that you fill out in writing to create an agency relationship. So what are we talked about? We talked about agency relationships. What types of relationships do you have? You have a special, a general, or universal relationship. You can have what do you use to create those relationships? Well, we use broker agreements, we use listing agreements, we use purchase agreements to create these relationships. Guess what? When we enter those relationships, you agree to do something and I agree to do something, right? You're the principal. If you hired me to do something, I'm your fiduciary. I owe you those duties. You cannot tell me to do anything illegal. I have to obey those orders as long as they're lawful. They might be awful too. But what I want you to see is how you tie contracts into agency. Agency creates the relationship. It pretty much creates that relationship that what y'all gonna be. The contract is the thing that creates the duties, and it spells out the responsibility of the parties. All right. Now, what we're going to talk about at the contracts is ownership. Okay, you listed a property, you bought a property. What did you buy? What did you sell? And there's a bundle of rights that go with that. And so hopefully we're starting to paint a story. Relationships, then the contracts in those relationships to buy what? Real property. So the next classes that we're going to talk about is real property. What's used to transfer that property, like general warranty deeds, limited warranty deeds, like Jazmine said. What are property ownership rights? How to own the property? When I buy said property, am I going to own it in am I going to be the sole owner? Am I going to be a tenant in common? Am I going to own it in a joint tenancy? So I'm trying to paint a picture so when you see these questions, you know exactly where they're coming from. Oh, that's the agency question because they're talking about relationships. Oh, that's a contract question because they're talking about fiduciaries and principles and stuff. Oh, that's about property ownership because they're talking about encumbrances and deeds and stuff and legal descriptions, right? Because if I started off with that stuff, that stuff is so technical. So the next thing we're going to talk about is property ownership, and that's technical. That's all definitions. Luckily, it's only about 8 questions on the test, and we only going to spend probably about a week on it, but it's a lot. So I just wanted to. I hope that you see the pathway that we're building with this. And as we get to the end, hopefully everything gonna make sense. All right. So there you go, right there. Jasmine wants to take any answers, questions, or I mean, she wants some questions so she can answer them. However, if you ladies don't have any questions, then there's nothing to answer. So let me know if y'all got any questions. Anything to say, Jazz? I know we might be having something coming up in the feed, but I don't think I've seen anything come up there. But it says they said thank you. Very good information. Thank you guys. Pretty much this is going to be a video. Go back and listen to it. Go back and watch it. If you know everything on this video, you should ace contracts. Like if this is a good template, but there was a lot of discussion in there that you may need to just go back and I'm gonna post this tonight to YouTube and I'll send out the link. But anything else, ladies? Anything else to say?
No, thanks for having me. Thanks for listening. And if you guys have any questions, reach out to Hen. He'll share my information.
Mm-hmm.
Uh, I do real estate, but I also do business law, personal injury, and I do litigation. So I love going into court. I love litigating. So if you guys need a lawyer in the future, you have a good one on this team.
The best lawyer that I know. So
Thank
good that I made her my partner.
you. Oh, thank you.
That's what's up. So, all right, ladies, we're gonna end this tonight. Let me know if y'all want to meet Saturday. We could put a bow on contracts. We're gonna we'll probably just answer questions. That's what we're gonna do next week. We got a whole week of contract questions. I'm gonna probably do that Monday and Thursday. I might even do 3 classes next week. I might do a couple classes because I want to get some more material in. But text me and let me know if Saturdays are good for you if you're gonna join, and then we'll go from there. All right.
All right, ladies, have a good night. Thanks
All right.
again for having me.
Take care, y'all.
Have a good night.
All right. Take care.